You're watching the Law and Crime Network, everyone. When we've been paying attention to bond court in Brevard County, Florida, this is in a defendant's first appearance. We oftentimes don't get a chance to pay attention to these things here on the Law and Crime Network, but being that we're just a few days into a new year, a lot of trials aren't scheduled to start until next week. We've been looking feverishly for cases for all of you to follow. We had one that was supposed to start, but it turns out they postponed it. So we are in a bit of a waiting game as we wait for some other criminal trials to pop up on the dockets across the country that we pay attention to on a regular basis. In the meantime, we're doing a couple of other things here on Law and Crime. We've been talking about some other legal topics that are in the news. One of them is California's decision to basically allow anyone within the state's boundaries to recreationally use marijuana. Along with me to talk about that is Jessica Jackson Sloan. She's a mayor of Mill Valley, California, and she also is an attorney out there. Jessica, good to see you again here on Law and Crime.
Thank you for having me on.
So I'm just curious, is your municipality dealing with this? Because my understanding is that there need to be local permits and then there need to be state permits, and this is a very complex regime of laws that dispensaries need to follow.
Absolutely. It is very complex, and I'll just say I'm now, as of December, the former mayor of Mill Valley. I'm still on the city council there, but I am no longer the mayor. I still got the gavel, though. Okay. So this is very complex, and it's something that we struggled with quite a bit. In fact, in the wake of Prop 64, many towns across the state, including my own, put into effect an emergency ordinance. We had to get that in within 45 days, basically preserving the status quo and saying we're going to take a little bit of time, have some hearings, public hearings, and think through how we're going to be able to implement Prop 64. So there were a lot of different areas for cities to consider. Saying, marijuana is legal and that's it is just the beginning. One of the things we had to look at is, do we want a dispensary in our town? Not every town has to have a dispensary. That, of course, is a zoning issue left to our planning commission and then ultimately to the council to decide. We have decided in the meantime not to have one, to wait and let a few other cities go first and see, really what the upsides, downsides are. We also had to look at whether or not we wanted to have a delivery service for recreational marijuana. We opted to continue our delivery services for medical marijuana, but not to add the recreational piece. And then there was questions around individuals growing marijuana and what we wanted that to look like in our community as well.
Yeah, it would seem to me that many municipalities are struggling with how to deal with this issue because, look, we know under the state law that dispensaries have to set up all of these permits. The state basically had to rewrite so many of its statutes to try to make this work. It's been an issue in banking because, of course, it's still illegal federally. And so if banks start moving money around with this, then it potentially could trigger some federal investigations. And you also have the issues of, okay, well, are people going to abide by the limits? The law limits recreational marijuana use to private property, obviously with permission. So people can't be out smoking it on the streets. They can't be out at parks. They can't drive while they're incapacitated or under the effects of it. And municipalities that invite this may have to deal with that, or municipalities that don't invite it may have to deal with it. I mean, is your municipality talking, and I'm sure you are, about the effects on the highways?
Absolutely, and this is going to be a lengthy conversation, ongoing, and I'm sure it will change over time. One other thing that, you bring up a lot of good points of things we're having to consider. Another thing is law enforcement. I mean, we have, 21 sworn officers. How much of their time do we want to be spending on something like going and making sure people are growing the right number of plants and making sure they have the right equipment in play? There's some inspections issues around having equipment to grow marijuana. We just had tragic fires up here in Northern California. So now, we wanted our planning department to really take a look at what does it mean to grow marijuana in your house. We know you can grow up to 6 plants under the state law. or a minimum of 6 plants under the state law. So, how many plants do we want to let people grow? What kind of equipment do we want to let them use? Are there any fire risks? Should this pertain to multifamily housing? Do we want to be allowing people to grow marijuana outside where kids maybe could access it? If so, what parameters do we want to have in place to ensure that kids aren't accessing it? And again, do we want to send our cops out there to count the number of marijuana plants that people are growing and make sure they're within the limits? Or would we rather use their time preventing crimes and solving crimes? So I think, there's a lot of considerations here that a lot of cities across the state are going to be wrangling with. There'll probably be some best practices, a lot of information sharing at some of our statewide conferences and whatnot, but we're definitely looking at what the other cities are doing as they're implementing this.
Have you faced any pressure from advocates who really wanted to push this through to say, hey, look, we've debated it, the state debated it, municipalities, get with it, this is legal now, we need to move forward and we need to move forward now?
Yeah, we got letters that were saying, 77% of our county voted for this. Why are you not implementing it? But we also got letters from parents saying, this could actually change the character of our community. Please be careful how you're doing this because we don't want our children to be adversely impacted. And I think, as with every issue as a local legislator, you really just have to balance the different community interests. And at the end of the day, you're going to do what you think is right for your community. But, it doesn't hurt to go slowly and make sure that we're getting as much information as we can when we're making these decisions. And at the end of the day, if somebody wants to leave the city jurisdiction and go into county jurisdiction or a nearby city that has a dispensary, that's an option that they are afforded. And, we'll continue to work on it in our town.
Is there any sense in California that there's a rush by municipalities to basically allow recreational marijuana? Because it would seem that once a couple of businesses get established, the market's going to hit a point of saturation. So all of a sudden you're going to have a few municipalities that go very, very quickly on this, at least this is my guess, and they'll become known as the places where people want to go for this, and therefore they're not only going to have a hook on the market in the early days, but also on the tax revenue and also on whatever negative effects come along with it.
And those are two very important words that you just mentioned there, tax revenue, right? We're all trying to do as much as we can to improve infrastructure, to build our parks, to ensure safety of our residents. And obviously that tax revenue is very necessary. You look at a city like Mill Valley, where we have a $32 million general operating budget. Tax revenue from marijuana could make a huge impact on that. But again, we did not decide to rush in despite that tax revenue, because we want to make sure that we're implementing this in a way that's safe for our community and in a way that doesn't change the character of the community. I think there are going to be some cities that do go ahead and start allowing dispensaries. I know that there's in several of them a permitting requirement, of course, and they're limiting the number of permits that you'll be allowed to get. So I think that goes to your saturation point. It's not going to be a free-for-all. You're not going to see a dispensary on every single corner in most cities. It'll probably be a well thought out plan in terms of how many permits they are issuing. And I'm sure, a lot of cities feel that they have an interest in going slowly, even on opening dispensaries, because they want to see, how that changes the character of their community and the environment around them. And like with anything, you don't want to oversaturate your town full of one thing. And I think in this situation, they'd be afraid of attracting too much business. So I know that the brick and mortar option is out there and being implemented in some cities, but I think there are going to be a lot of cities that say, we'll allow a delivery service for recreational as well as for medical marijuana, but we're just not ready to have that dispensary there yet.
Yeah, I mean, the bottom line is that this regulatory regime has, from what I understand, tripped a few people up. There was an incident in Mendocino County where apparently a truck that was carrying close to 2,000 pounds of marijuana wound up getting pulled over for some minor traffic infraction, and I think it was involving like the running lights on the vehicle or something like that. And the highway patrol finds out that it's full of marijuana, and they turn around and they go after the operators. And this was just within the last couple of weeks, and say, hey, wait a minute, this law doesn't kick in until January 1st. What are you doing? They filed charges. I'm curious to see exactly whether or not the local prosecutor there is going to actually take the case, because I don't know about you, but how would a jury take it if you're trying a case in front of a jury saying, well, this is part of an operation that this given day would have been illegal, but now it is legal and we still want to go after them?
Yeah, and I think that's a very good point. And I think, that speaks to also why Proposition 64 actually allowed for people the day after it was passed to apply for early release and to apply to have their records expunged. There was about 6,000 people here in California prisons that were in there for, growing and distributing marijuana. So it's very interesting sort of just stepping back and looking at the state of where our country is on marijuana. At Cut 50, the nonprofit that I run, we've actually worked on commutations, clemencies, federal cases where people are serving life for marijuana, whereas, now in the state of California, it's recreationally legal. So the laws are continuing to be in flux, and I think you're going to see a lot of situations that are very unfair because had a person waited a couple weeks, had a person been in a different state, had a person been in a different jurisdiction, even within the same state, they would have had a different treatment under the law for the exact same action. I know that there's also, 1 million people who've been convicted of marijuana-related felonies or misdemeanors that could have their records changed at this point. And, I know your show has addressed before the incredible number of collateral consequences that come with a criminal conviction. But these are folks who before weren't eligible for a loan on a house or for financial aid to go to college, or who maybe were barred from getting a certain kind of occupational license and were unable to move forward in their lives and succeed because of the marijuana charge, that are now going to be able to have their records expunged and pursue their dreams.
And look, that's a big issue. Many states are looking at. I mean, even conservative states, traditionally conservative states like Missouri, have radically changed their expungement laws, and some of those took effect with the first of the year. You've got Governor Cuomo here, where I sit in New York, talking about making criminal justice reform part of his agenda this year. Ironically, saying that the Empire State has been at the forefront of liberty initiatives over the years, yet New York is one of 10 states that basically allow prosecutors to turn over evidence to the defense on the literal eve of trial, whereas other states have turned around and said, for fairness, we need to turn that information over earlier so that the defense can be properly prepared when trial hits. Only 10 states allow that. New York is thinking about getting with the program at this point. So look, criminal justice reform is a big topic. A lot of states are looking at it, and this marijuana initiative in California is part of it. So we certainly appreciate your thoughts on that matter, but I have one last question as it comes to this. Were you personally in favor of Prop 64 or against it?
I saw that there was going to be some issues around implementation. I'm a big fan of involving local elected officials in the drafting and in the process of passing it. So for me, this was an issue of making sure that we had something that was easy to implement and that was going to allow communities the discrepancies that we have been allowed, the discretion that we have been allowed to implement the legislation in a way that fit for our community. And of course, as National Director of Cut 50, I don't think I have to say, but I'm in favor of anything that allows people who are in prison for a second chance, an opportunity to come home and move on with their lives. So very much in favor of that.
Yeah, so let's move on to another case that we've been taking a look at, and this is the Quinton Tellis trial in Mississippi. This involves a victim named Jessica Chambers, who was set on fire and who ultimately died of the wounds that she received allegedly at the hands of this particular defendant. Now, Jessica, this was a case where the jury hung on the charges, and the state is going to go back and retry him again. One wonders if the state has enough to try to get a conviction the second time around, because this wasn't just one holdout juror. This was a pretty even split of jurors the first time around who were stuck on this.
And confused, right? When you're looking at what happened here with this mistrial, it's almost confusing how confused everybody was. When they first were asked if they had come to a verdict, they said, yes, we've reached a verdict. But then once informally polled by the judge at the prosecutor's request, it turned out that they were very split on this, and there was a mistrial. Now, I'm not sure exactly what facts it was that caused this split. I know that Jessica Chambers' last words herself came into play in a big way in this case. She was able to speak to some extent, although she had pretty severe injuries to her mouth and to her throat, but she did speak to some of the first responders and allegedly said the name Eric, which is not Quinton Tellis, and the prosecution has said this discrepancy is based on those injuries she had sustained, making it impossible for her to really vocalize that name. But this might end up as a guilty verdict, given the case. I know that the community is continuing to struggle with what happened in their community and the horrific nature of the tragic facts that happened there.
Yeah, exactly. But of course, our interest is always in justice being served, and this whole episode is just horrific. I mean, there are very few worse ways one could picture to die. This is one of them, if not the worst. But did this particular defendant do it? You have the last words of the victim. You have at least some evidence that the defendant may have been on his way out of town to buy this prepaid cash card that he was talking about. That timeline seemed like it was really concerning for the defense, and rightfully so, because look, if he had said his goodbyes and was on his way out of town, then he couldn't have been the one involved.
Yeah, and I think a lot of the prosecution's case really was based on the fact that they'd spent so much time together that day, and of course, some of the cell phone evidence. But as you said, there are some very strong points for the defense, and I think this is probably why the jury reached such a confused non-verdict, is because there were good points on both sides of the aisle, and I'm interested to see how they play out in a new trial.
Anytime a case ends with a hung jury, of course, as a prosecutor, you have to fear that maybe you didn't sell something hard enough, or do you have a strong enough case to even get a conviction to override the presumption of innocence, to override the heavy burden of guilt beyond a reasonable doubt. But in theory, it also gives one time to retool an argument and say, hey, maybe I should have focused on this a little bit more and this a little bit less. And I'm guessing, Jessica, that you're in agreement with me that that's probably exactly the kind of post-game synopsis that the prosecution and also the defense is in the midst of doing right now.
Yeah, I was going to say, and also the defense as well. And there are a lot of factors that are going on at a trial at any given time. People in the courtroom, things that are happening. As a defense lawyer, your client might be pulling on your sleeve, trying to talk to you, trying to communicate with you. And there's an element of surprise. You're never entirely sure, even if you've done preliminary, obviously, you're never entirely sure what somebody is going to say on the stand. So in a lot of ways, they've had, their trial now. They know what people are going to say. They know what they can expect. Perhaps they've had an opportunity to really review the record, look back, see where there might have been inconsistencies in people's stories once they got on stand, and really prepare their arguments for the next go-round.
Exactly, and I think that one thing I can say for the defense team in this case specifically is trial management, trial procedure, trial demeanor is very important when you're a defense attorney, because look, your client is sitting there accused of something heinous, something awful. And I think that the defense did a very good job of doing what I was always taught in law school, and that's to wear the white hat no matter what side you're on. I think that the defense came across as friendly. They came across as really just trying to get to the truth here, and that's exactly what a defense attorney should be doing.
Absolutely, and I think a defense attorney also needs to be humanizing their client. You know, at the end of the day, the jury is human beings. You know, they are looking to see, you know, how this person is acting, what, if there are people who care about them in their lives, if there are people who can vouch for their character. They're looking for that emotional connection with the person whose life they're about to determine. So I think the defense also did a pretty good job on that. And of course, there's always room for improvement, but that is a crucial aspect of being a defense attorney, is to be able to humanize your client so that the jury thinks about them as a human being when they're deciding whether or not to sentence them to die in prison.
Yeah, exactly. And you know, look, a lot of people might look at this guy and say, look, this guy's bad news. He's facing murder charges in Louisiana in an unrelated case. You know, and it goes back to something that I talk about here frequently and say, well, you know, we're not supposed to be convicting people in this country by throwing a ton of accusations at them and then assuming that they fit the mold of a particular type of behavior. And I think that they were really cautious in this trial, which ended in a hung jury, in making sure that word of whatever may or may not have happened in Louisiana didn't wind up in front of the jury in this particular case.
Yeah, and that's important. I mean, look at the picture you guys just showed. You know, it's got the defendant sitting in front of a sneaker rack in a store with a snarl on his face and a you know, tank top with tattoos showing, right? That in itself, people are going to see that and they're going, oh, that guy looks like bad news. If he was walking down the street towards me, I'd probably cross the street, is what they're thinking. So, you know, as a defense attorney, you want to be telling that other side. You want to be talking about that person as a son, as, you know, a classmate. If there's any positive sort of character testimony that you can get in there that shows this person is more than these bad decisions they've made. Yes, they've made bad decisions in their life, but they're actually also capable of making good ones as well. And maybe, you know, there are mitigating factors for why they've made some of those bad decisions. If they're coming from poverty, if they're coming from an abusive situation, if they have an addiction, being able to really give that thorough understanding to the jury so that they can look at the person holistically, not just by their rap sheet.
Yes, and I always look at it up against the standard of beyond a reasonable doubt. And that phrase has been defined, redefined, argued, discussed, and attempted to be explained so many times that we can't even count at this point. But I always look at it and say, you know, look, if I were sitting on the jury, would I be able to walk home after delivering a verdict and feel absolutely comfortable that the truth would point to this defendant being guilty of the absolute specific language of the crime charge? You know, not just throwing the top charge at somebody because a victim died a heinous death. You know, you really have to get in the language of what the charge is and whether or not the crime fit it, and am I convinced beyond a reasonable doubt. And it's supposed to be a standard, as I understand the research, that a juror can walk home and not have any lingering suspicion after delivering the verdict that maybe something just didn't add up.
Yeah, and that's why we've got it organized the way we do to evaluate these kind of cases as a juror, right? You've got your elements, you've got the evidence that's put forth in front of you. You get an opportunity with your fellow jurors to go back in the deliberations room to take a look at those elements, to look at the evidence that was introduced, to look at the witness testimony, to assign credibility to the testimony that you hear, and to actually see if those elements have been met. So there's a little bit of a science to it, or there's supposed to be. But like you said, you know, there's still sort of a vague lingering in the language. What is beyond a reasonable doubt? What is a reasonable doubt, right? Anybody who has sentenced somebody to die in prison might one day wake up in the middle of the night and think, you know, oh, I remember when they said this and this. Maybe there's some way that they, you know, were on their way out of town, or maybe she was saying somebody else's name, and the detectives should have done a more thorough pursuit of every Eric in her life. So, I think there are lingering doubts for anybody who's on a jury, but there has been an attempt to make the process a little bit more scientific so that we're able to reach conclusions and actually come to closure in these cases.
Let's talk about jury diversity here. This happened in a very diverse community, a pretty even split African American and white. The jury reflected that. There were 6 men, 6 women, 7 African Americans on this jury, 5 Caucasians on this particular jury. So a dead even split gender-wise and close to an even split racially. From what I recall, listening to the actual votes on this split jury that resulted in the Jessica Chambers case, it was not a stereotypical split of not guilty from the African American members and guilty from the whites who were on the jury. It was a true mix. Do you think the jury diversity did play any part in this at all, though?
Well, I think jury diversity is very important. We still live in a fairly segregated society. So it's important that you have different diversities on the jury to represent more thoroughly, the fabric of society. But I think particularly in this case, you've got sort of some race-driven facts. You've got a white defendant, white victim, and you've got a black defendant. It's important to make sure that the people who are on that jury represent the diversity in the community, and also that they're able to, openly, without bias, listen to all of the evidence despite the racial makeup of the victim and the accused.
Yes, I agree with the point about making sure the juries are diverse, because it does add perspective into the deliberations. And of course, we want to have a democracy where everyone participates. So we're in the midst of reviewing testimony in this case. Jessica Jackson Sloan, attorney, founder of a nonprofit in California, currently on the city council, recently departed mayor. Make sure I get your title correct and complete all the way across the board. We really appreciate your opinions here on Law and Crime.
Well, thank you for having me on.
All right, we're going to continue our review.